As a real estate agent, when selling a property, there are 6 key milestones to achieve when going through the standard process of a fee simple property. In this video, we will be discussing the following: engaging a vendor client, taking a vendor's property to market, receiving offers from potential purchasers, entry into the sale and purchase agreement with a selected purchaser, payment of a deposit, and settlement for a sale of property.
When engaging with a vendor client, licensees need to ensure that they are acting in the best interest of their client. Examples of these are things such as following lawful instructions from the client, ensuring the client has a right to seek legal and specialist advice prior to making any informed decision, and ensuring that there's regular communication between the licensee and the vendor. Most importantly, licensees need to ensure that an agency agreement accompanied by an approved guide is signed and completed by both parties before marketing and selling a vendor's property. These are in compliance with Rules 9.1, 9.6 and 9.7 of the Code and Sections 127 of the Real Estate Agents Act. When taking a vendor's property to market, an agent needs to exercise skill and care when conducting market appraisals, and they need to be supported by relevant market information. When no information can be found, the agent must communicate this to their client in writing. A licensee cannot advertise property on the terms that are different from what is authorized by the client. Terms on how the property will be marketed is stated on the agency agreement, including any expense that is to be agreed by both parties prior to the commencement of the agency. This is in compliance with Rules 10.2, 10.6 and 10.9 of the Code.
Receiving offers from potential purchasers. Under the Code, Rule 10.10 requires licensees to submit all offers to their client in writing. This is in relation to the Property Law Act, where all contracts for deposition in land are not enforceable unless communicated in writing. In this case, between Mr. Hachachi and the CAC, Rule 6 of the Code is also important when handling offers from potential purchasers in this case. The licensee crossed out the original purchase price and gave a counter offer without initials from the vendor or himself as the authorized agent. The licensee had misrepresented the buyers into believing the vendor had signed the counter offer and remained silent about signing the counter offer as a vendor's agent. The licensee breached rules 5.1, 6.2, 6.3, 6.4 as a result and was penalized with a fine of $3,000.
When entering into a sale and purchase agreement with a selected purchaser, a licensee needs to ensure that the agreement contains all material particulars. The opportunity to seek legal and special advice and a reasonable period of time to do this must be communicated between the licensee and the buyer. The licensee must not take advantage of the purchaser's inability to understand relevant documents, and these are requirements that comply with Rules 9.7, 9.8 and 9.9 of the Code.
The deposit amount is included in the ADLS SPA and must be paid to either the vendor or the vendor's agent upon the agreement being signed and communicated by both parties as per the ADLS SPA. The deposit, generally being 10% of the purchase price, is part payment of the total purchase price of the house, and the remaining will be paid at a later date. Under the REAA, Sections 122 and 123, any money that is received by the agent for a transaction must be held for a period of 10 days before the agent is able to pay that money to any person. The money that is paid to the agent must be paid to the person that is lawfully entitled to the money. If there is any doubt on who is lawfully entitled, the agent must take all reasonable steps to find who is entitled to the money.
The settlement date will also be included in the ADLS sale and purchase agreement. It is the date where the purchaser of the property takes over legal ownership of the property. Also, this is the date where the purchaser pays the remaining sum of the money to the previous vendor. All rights and legal ownership are transferred to the new property owner on this day. The real estate agent may still have some liability even after the settlement date of the property. If they have perhaps acted negligently about a certain issue with the property, that only comes to the attention of the new vendor after settlement. Mr. Rankin, the real estate agent, sold a property at Pahitua to Mr. and Mrs. Brockton. After the settlement of the property, it was discovered the house had methamphetamine contamination. The licensee knew of this prior to the sale of the property and failed to disclose this to the new purchasers. 2 charges were brought forward by the Complaints Assessment Authority, the first being misconduct under Section 73 of the Real Estate Agents Act. The tribunal found that Mr. Rankin had breached withholding information part of the rules from the Rules 2012 Section 6.4 and Section 10.7, failing to disclose this defect. The tribunal found serious incompetence and decided that this was a misconduct under Section 73 of the Real Estate Agents Act 2008. By not informing them of this big issue with the property, that would have a huge influence on their purchasing of the property. The tribunal was satisfied that the charges are proved on the balance of probabilities and fined Mr. Rankin $3,000 and suspended his license for 3 months.
We hope that this video has been insightful and wish you all the best for the future endeavours in the world of real estate.